Hello, everyone. Today we're going to talk about indemnification clauses and contracts, what they are, why they matter, and some critical pitfalls to avoid. This video is really important because indemnification clauses are complicated, they're commonly misunderstood, and they impact the risks to your business. Indemnification clauses are provisions in contracts that require one party to compensate the other for losses or damages under certain circumstances. They're crucial in business contracts because they allocate risk between the parties and can provide important protections. Now look, this is where things get interesting. There's a surprising gap in many indemnification clauses that can leave businesses exposed. What we need to do first is distinguish between direct and third-party claims. Direct claims are those between the actual parties to the contract, whereas third-party claims involve those outside the contract. Many people assume that indemnification clauses cover both types of claims, but that's not always the case, especially in Texas, Delaware, and New York, and other states, but not all states, so be careful if you're watching this video. There's also an important interplay between indemnification and the remedy section. Remedy clauses can limit direct or inter-party claims. This is important because if your only remedy is indemnification and your indemnification clause doesn't expressly include direct claims, you may not have a claim against the other party, even if they made an untrue representation. To ensure comprehensive coverage, consider two approaches. One is the bulk of this presentation, which is including direct claims in your indemnification clause. That's your best practice. Another thing I'm mentioning, which is kind of secondary to this presentation, is beefing up your remedy section, including direct and representation claims in the remedies section. So what does all this mean for your business, and why do you care about this? The risks of standard indemnification language can be significant. You might think you're protected against certain losses, only to find out you're not. In a dispute, you could be left without recourse for breaches of representations and warranties. For example, imagine discovering after an acquisition that the seller misrepresented the condition of key assets. If your indemnification clause doesn't explicitly cover direct claims, you might have no way to recover your losses. So let's take a look at some key takeaways for your contract negotiations. First of all, you have to have really clear, specific language. This is really important, and its importance can't be overstated. Second, ensure coverage for both direct and third-party claims. And third, pay particular attention to the remedy section and what it covers or excludes. Those are the main things you really need to get from this presentation. So I'm going to show you a problematic indemnification clause. And the reason it's problematic for purposes of this presentation is because it only covers third-party claims. It doesn't cover direct claims, which, like I said before, can matter if there's some limitation in the remedy section or somewhere else in the contract limiting you to just the indemnification provision. You really need to look at all the interplay of the provisions, which is why this stuff gets so complicated. So I'm going to read this section, or this indemnification clause. It says, seller shall indemnify, defend, and hold harmless the buyer indemnities from and against any and all losses and liabilities, including reasonable expenses of investigation and reasonable attorneys and other professional fees and expenses arising from, in connection with, or related to any action incurred or suffered by the buyer indemnities with respect to blah, blah, blah. Okay, this clause looks great. This looks like probably any other indemnification clause that you've ever seen. What's the problem with it? Isn't this boilerplate? Isn't this standard? Yeah, but it only covers third-party claims. It doesn't cover direct claims, so claims between the parties themselves. You have to explicitly include direct claims if you want that to be covered. And like I said, but I'll say it again because I know this gets really complicated, why does this even matter? Let's say somewhere else in the contract, the parties included an as is, where is language, or something to the effect of your sole remedy under this contract shall be the indemnification provision. And then you think you have a claim for breach of contract against the other side, but you really don't, because if your sole remedy is the indemnification clause, and the indemnification clause only covers third-party claims, not direct claims, then you really don't have any claims for breach of contract, and you can be in a really precarious situation. So let's look at a comprehensive indemnification clause. And this one is better. So here are the tweaks. To the fullest extent permitted by law, sellers shall indemnify, defend, and hold harmless the buyer indemnities from and against any and all losses and liabilities, including reasonable expenses of investigation and reasonable attorneys or other professional fees and expenses arising from, in connection with, or related to any action, whether involving a third-party claim or a direct claim between the parties, and any incidental, direct, indirect, or consequential damages, including any lost profits or diminution in value, collectively damages are incurred or suffered by the buyer indemnities with respect to ... So just a few little tweaks here. It talks about third-party claims. It talks about direct claims. You're probably going to have a definition for direct claims. You're going to have a definition for third-party claims. There's a lot of ways you can tighten this up in the contract, and there's not just one way. And you can also have indemnification procedures for your direct claim, indemnification procedures for your third-party claims, to really button it up and spell out that these things are different. So what are best practices moving forward for your business? One is work with experienced legal counsel. This part of the contract, it can be seen as boilerplate. It's really not. There's a lot of nuances to indemnification, waiver of remedies, and the interplay between everything. And it's important to use an experienced corporate law attorney, an attorney that's negotiated these things before and understands all the nuances and why the language is really important. And then it's important to regularly audit your existing contracts for potential gaps. And this is something that attorney can do. You could do it with some of the knowledge in this video, and then bring it to an attorney and say, hey, I need these changes made to my contracts. So in essence, what I want you to get from this presentation is that indemnification provisions they're complicated, and they're oftenly misunderstood. I've had attorneys on the other side of deals not understand that indemnification can include both direct claims and third-party claims. If you want direct claims to be covered in your indemnification agreement, you need to expressly put it in. On the other hand, if you don't, you should just leave absent any reference to direct claims. And the other thing I want you to get from this presentation is it's important to be proactive about your contract management and managing your contracts and knowing what the terms in your contracts even mean. And if you need help with any of that, you can watch some of the other videos. You can also reach out to an attorney at the firm or any other corporate law attorney or someone that's experienced in these kinds of matters.